Hello and welcome back to another edition of Deep Dive Daily. I'm buzzing, not with caffeine, though maybe a little, but because I've been staring at a specific contradiction in the Indian Constitution all morning and, well, it is driving me up the wall.
It's great to be here.
It's one of those things that, once you see it, you can't unsee it.
I love it when you get stuck on a contradiction. That usually means we're about to hit on something really important. So what part of the Constitution is it this time?
It's this whole idea of the contract, We spend so much time analyzing the deal we have with the state. We talk about fundamental rights all the time. I give you my allegiance, you give me freedom of speech. That's Article 19, equality under Article 14, the right to life, Article 21. It feels very transactional.
It is. I demand. The state provides.
Exactly. But then you flip the page, metaphorically speaking, to Part IVA of the Constitution, and suddenly the entire script flips. The state stops giving and, well, it starts asking.
Ah, you've landed on the fundamental duties. The mirror image, as they say.
Exactly. The fundamental duties. And the more I looked at our source material for today, we're really digging into Chapter 9 of Indian Polity and the legal history around the 42nd Amendment. The more I realized this isn't just some, friendly list of good behavior.
No, it's not.
It's a legal minefield. It's a section of the Constitution that feels like a stern parent wagging a finger. But, and here is the contradiction, it supposedly has no power to punish me if I ignore it, or does it?
And that is the million-dollar question, isn't it? Supposedly is the key word there. A lot of people, even lawyers, they tend to dismiss fundamental duties as, well, toothless.
Just a polite suggestion box.
Yeah, a polite suggestion box from the government. But I think our mission today is to completely shatter that misconception.
That's what I want to get into. I want to move past the civics class summary of, be nice to your fellow citizens. I want to understand the legal framework, the actual machinery that gives these duties teeth. Because if I'm reading these statutes correctly, and we're going to look at some very specific acts today, violating a duty can actually land you in prison, even if the Constitution itself doesn't explicitly say so.
Precisely. We are going to explore the teeth of the duties, the specific acts, the specific articles. We also need to dissect the why and the when of their creation, which means talking about the political pressure cooker of 1976.
Oh, absolutely.
And we need to ask that more fundamental question. Why, in a democracy, did the state feel the need to codify the behavior of its citizens in the first place?
1976, the year of the emergency. You can't talk about this without talking about the politics, but let's start at the very beginning. If I go back to the original 1950 text, the one Ambedkar handed to Rajendra Prasad, I'm not finding this list, am I?
You are not. And that is a fascinating silence in the original document. The original Constitution had Part 3, which is fundamental rights, and Part 4, the directive principles of state policy.
So the state had limits and the state had goals.
Exactly. The state had duties to its people. But the citizen was, I guess, assumed to be responsible.
Assumed. That's doing a lot of heavy lifting for a brand new democracy, isn't it? Why did the framers, who were so meticulous about everything else, why did they leave this out? Was it just an oversight?
Not at all. It was a very deliberate philosophical stance. You have to remember the worldview of the Constituent Assembly. They were deeply, deeply influenced by Western liberal democracies.
Like the U.S., the U.K.
The USA, Canada, France, Australia, take your pick. None of them have an exhaustive list of citizen duties in their constitutions.
And what's the logic there?
The logic is that in a free society, duties are inherent. They're implicit. You don't need to tell a free person, do not betray your country. You assume that their freedom, their stake in the system, makes them loyal.
So listing the duties would almost imply a lack of trust. Like if I have to tell you not to be a traitor, I've sort of already lost the argument.
Precisely. They trusted the, for lack of a better word, the vibe of the newly independent Indian citizen. They believed that the long struggle for freedom had already instilled that sense of duty. To write it down would have felt, well, redundant.
Maybe even a little condescending.
Perhaps, yes. But that trust, it didn't last forever. Fast forward just 26 years. The vibe has definitely curdled. It's 1976.
Now, the context here is absolutely critical. We're not talking about a random Tuesday in Parliament.
No. We're in the middle of the internal emergency, which ran from 1975 to 1977. Civil liberties are suspended. Opposition leaders are in jail. The press is heavily censored.
A dark time, for sure.
And the ruling Congress Party, led by Prime Minister Indira Gandhi, has developed a new theory for what's gone wrong in the country. And their theory is, the problem isn't the state. The problem is the people.
Wow. That is a hell of a pivot. It's not me, it's you.
Essentially, yes. The official narrative being pushed was that Indians had become too obsessed with their rights, always agitating, protesting, going on strike, and in doing so, had completely forgotten their debt to the nation.
They needed to be reminded of their obligations.
They needed to be made conscious of their obligations. That was the term used.
So, to make them conscious, they formed the Swaran Singh Committee. I've read about this committee, and frankly, it sounds less like a review board and more like a fix-it squad for the Constitution.
That's a good way to put it. Their mandate was very specific. Recommend a chapter on fundamental duties.
And their work led directly to the 42nd Constitutional Amendment Act of 1976.
Yes. An amendment so massive, so sprawling, it's often called a mini-constitution in itself. It changed so much. But for our deep dive today, the key addition was a brand new Part IVA, which consisted of just one single article, Article 51A.
And the government at the time, they weren't subtle about this, were they? They flat out called the omission of duties in 1950 a historical mistake.
Which is a staggering claim when you think about it. They were essentially saying that Ambedkar, Nehru, Patel, all the founding fathers, they got it wrong.
And this needed to be corrected.
It needed to be fixed. The argument was that rights and duties are organic. They're two sides of the same coin. You can't have one without the other. And this is where the big ideological shift happens. They stopped looking west at the US or UK for inspiration.
And started looking east.
To the Soviet Union. The 1936 Soviet Constitution was very explicit on this point. It said rights and duties are inseparable.
That's a fundamentally different model of citizenship, isn't it?
It's a completely different worldview. In the liberal model, I have rights because I am a human being. They are inherent. In the socialist model, I have rights so that I can perform my duties to the collective, to the state.
That's a stark way to put it. My rights are conditional on my utility.
It's a bit of a simplification, but yes, that's the core idea.
Yeah.
And India in 1976 was leaning very heavily into that socialist rhetoric. It's interesting to note, the only other major democracy that has a list of duties is Japan.
Really? Japan?
Yes, but the Japanese context is very different. It's deeply rooted in their cultural and social traditions of collective responsibility. The Indian context of 1976 was almost purely political.
Okay, so Swaran Singh and his committee sit down to draft this list of duties. And this is the part that really caught my attention in the notes. We ended up with 10 duties. Originally, it's 11 now. But the committee actually recommended some, frankly, terrifying things that didn't make the cut.
And we should all be very thankful for that. This is one of the great what-ifs of Indian legal history. If the government had accepted all of Swaran Singh's recommendations, we would be living in a very different and likely much more authoritarian country today.
So let's look at what got rejected. The first big one was what you could call the penalty clause.
Right. The committee recommended that Parliament should be empowered to impose specific penalties or punishments for any non-compliance with these duties.
So not just a moral suggestion, they wanted real consequences.
They wanted the Constitution itself to say, if you fail to do your duty, the state will punish you.
Imagine the chaos of that. If I don't cherish noble ideals, which is one of the duties we'll get to do, I get fined for that. Do I go to jail? How on earth do you even police something like that?
You can't. Not without a massive surveillance state. That was the fear. It would have turned every citizen into a potential criminal based on incredibly subjective interpretations of duty. But the second rejection was, in my opinion, even more dangerous.
This is the one about judicial review.
Yes. They wanted to strip away judicial review for these laws.
The no questions asked clause.
Essentially, they proposed that if Parliament passed a law to punish you for breaching a duty, you could not challenge that law in any court on the grounds that it violated your fundamental rights.
Whoa. Okay, so let's walk through that. Let's say the government passes a law saying to uphold the unity of India, all citizens must report their neighbors' suspicious activities.
Okay.
And I say, hey, that violates my right to privacy under Article 21. The court would have to throw my case out.
The court would have to say, sorry, can't help you. This law is enforcing a fundamental duty, so it's immune from challenge.
That would have made duties superior to rights. It's a backdoor to bypass Article 19, Article 14, Article 21, everything.
It would have completely upended the basic structure of the Constitution. Thankfully, even during the height of the emergency, the government realized this was a breach too far. They rejected it.
And then there's the third rejection, the one that hits everyone in the wallet.
The duty to pay taxes.
The committee wanted to make paying taxes a fundamental duty. It sounds logical on the surface, right? We all have to pay taxes anyway, so why not just put it in the Constitution?
I have to assume every finance minister since 1976 has had a daydream about this.
So why did they reject it? It seems less dangerous than the other two.
Well, the sources are a bit silent on the exact cabinet discussion, so we can speculate based on legal theory. If paying taxes becomes a fundamental duty, what does that imply about those who are too poor to pay any income tax?
Are they constitutionally bad citizens?
Exactly. Or, let's flip it. If I'm a billionaire and I pay a huge amount of tax, does that give me more of a claim to good citizenship than someone who doesn't? It risks creating a kind of tiered citizenship based on wealth.
I see. It turns the entire citizen-state relationship into a purely financial transaction.
Precisely. Also, there's a practical problem. Tax laws are statutory. They change every single year with the budget. If you anchor a financial obligation in the Constitution, it creates incredible rigidities. What happens if I dispute a tax bill with the department? Am I now violating the Constitution itself?
It would have flooded the Supreme Court with tax cases disguised as constitutional crises.
You'd have tax lawyers arguing constitutional law. It would have been a mess. So it was much smarter to keep the tax code in the tax code. Don't elevate it to the same level as cherishing noble ideals.
Okay, so we dodged a few bullets there. No penalty clause, no immunity from courts, no tax duty. What we were left with was Article 51A, 10 duties in 1976.
Now 11, but yes, it started with 10.
Let's actually look at the list. And I don't want to just read them out like a textbook. I think it makes more sense to categorize them because they feel like a bit of a grab bag. You have very specific instructions like respect the flag, right next to philosophical advice like strive for excellence.
That's the best way to approach it. Legal scholars generally break them down into 3 buckets to make sense of the list. First, you have civic or political duties. Second, ideological or moral duties. And third, what we can call progressive or modern duties.
All right, let's start with the civic duties. These seem like the non-negotiables, the bedrock of being a citizen.
They are, and it starts with Article 51A, Clause A, to abide by the Constitution and respect its ideals and institutions, the national flag, and the national anthem.
This one seems pretty clear-cut. You can't be a citizen and also actively disrespect the core symbols of the state. It's a baseline requirement.
It is. Then you have Clause C and Clause D, which are also in this civic bucket.
Right. 51AC is to uphold and protect the sovereignty, unity, and integrity of India.
The Don't Break the Country Clause.
And then 51AD, to defend the country and render national service when called upon to do so.
That phrase, when called upon to do so, that's the important bit.
That's the draft, isn't it? That's conscription. We don't have it in India now, but this article lays the legal groundwork for it if it's ever needed.
It absolutely does. It's a sleeper clause. If India were ever in, say, a total war scenario, the government wouldn't need to pass a new constitutional amendment to draft citizens into the army. The duty is already there in the Constitution. You must render service.
Okay, so that's the civic bucket. Pretty straightforward. Now let's move to the second bucket, the ideological or moral duties. This is where the language gets a bit flowery.
And very subjective. Take Clause B. To cherish and follow the noble ideals that inspired the national struggle for freedom.
Noble ideals. I mean, that's the tricky part, right? The freedom struggle was a massive, complex movement. Gandhi had ideals, Subhash Chandra Bose had ideals, Bhagat Singh had ideals. They didn't always agree on methods or even final goals. So which specific ideals am I supposed to cherish?
And that is the heart of the criticism against this clause. It's vague. The intent, of course, was to codify the broad spirit of the freedom movement. Nonviolence, democracy, secularism, anti-colonialism. It's meant to be a moral compass.
The compass that different people could read differently. Okay, what's next in this bucket?
Clause E. This one is huge. To promote harmony and the spirit of common brotherhood amongst all the people of India.
Transcending religious, linguistic, and regional or sectional diversities.
This is the anti-communal duty. It's a direct command to be secular in your public life. But the second half of that sentence is just as important and often overlooked.
The part about women.
Yes. To renounce practices derogatory to the dignity of women.
That is fascinating. In 1976, they specifically singled out the dignity of women. Not children, not the elderly, not minorities in general, women.
It was a very progressive inclusion for its time. It was a clear recognition that Indian culture, which, by the way, we're supposed to preserve in the very next duty, sometimes contained practices that were actively harmful to women.
Like sati or dowry or maybe even certain inheritance customs?
Exactly. Sati, dowry, female infanticide. This duty sets up a fascinating internal conflict in the Constitution. You must preserve culture, as per Clause F, But you must also renounce parts of that culture if they hurt women, as per clause.
E. So it establishes a legal hierarchy. The dignity of women trumps tradition when they clash.
Theoretically, yes. That's the idea. And as you mentioned, that leads directly into Clause F, to value and preserve the rich heritage of our composite culture.
The key word there being composite.
Yes. It's a deliberate nod to the fact that Indian culture isn't a single monolithic thing. It's a blend of centuries of influences: Hindu, Muslim, Sikh, Christian, tribal, and so on.
Then there's clause.
Clause I, to safeguard public property and abjure violence.
Abjure, a very fancy word for give up or renounce. This one seems very much a product of its time. This was clearly aimed at the protesters and strikers who were burning buses and trains, wasn't it?
Oh, 100%. The Congress government in the 70s was tired of strikes and agitations destroying railways, post offices, public buildings. This was the direct constitutional message. If you burn a bus, you aren't just a vandal. You are a bad citizen failing your fundamental duty.
Okay, now for the third bucket. The progressive or modern duties. These are the ones that feel surprisingly ahead of their time.
They are very forward-looking. Let's start with clause. To protect and improve the natural environment, including forests, lakes, rivers, and wildlife, and to have compassion for living creatures.
Environmentalism written directly into the Constitution in 1976.
India was one of the first countries in the world to do this. It's quite remarkable. And then my personal favorite, Clause H.
Ah, yes, the famous one.
To develop the scientific temper, humanism, and the spirit of inquiry and reform.
Scientific temper. I really want to pause on this. Most constitutions around the world invoke God or some divine authority. Ours invokes science. That is a very, very Nehruvian legacy, isn't it?
It is deeply Nehruvian. Jawaharlal Nehru spoke about scientific temper all the time. It's essentially a constitutional attack on superstition and dogma. It says that being a good Indian citizen means being rational. It means questioning tradition, not just blindly following it. It's a duty to be a critical thinker.
Which is deeply ironic considering the government that wrote it was in the middle of the emergency and didn't really want people questioning them.
The irony is palpable, yes. Question everything. Except us. And finally, in this bucket, you have clause J. To strive towards excellence in all spheres of individual and collective activity so that the nation constantly rises to higher levels of endeavor and achievement.
The do better clause. It's a nice motivational poster, but legally, how on earth do you enforce excellence?
You don't. That one is purely aspirational. It's about setting a national ambition.
And before we move on, we should definitely mention the 11th duty, the late arrival to the party.
Right. Clause. This was added much later, in 2002, by the 86th Amendment Act.
And it says,
It mandates that a parent or guardian must provide opportunities for education to their child or ward between the age of 6 and 14 years.
this was the other side of the coin for the right to education, which was met a fundamental right around the same time.
Exactly. The state has a duty to build the school and provide free education, and the parent now has a fundamental duty to actually send the kid to the school. It closes the loop.
So that's the list, 11 duties. But here's the problem, and this is where I think a lot of our listeners get stuck. We have this list. I'm supposed to have a scientific temper. I'm supposed to strive for excellence. But if I decide to be a lazy, superstitious person who couldn't care less about the environment, what actually happens to me?
And that question brings us to the crucial legal concept of justiciability. This is where the rubber meets the road.
Or, as some critics would argue, where the rubber completely misses the road. Because these duties are explicitly non-justiciable.
That's correct.
Yeah.
They are like the directive principles in that respect. You cannot go to the High Court or the Supreme Court and file a writ petition asking for a writ of mandamus to force a citizen to perform their duty.
Let's just unpack writ of mandamus for a second for everyone. That's a type of court order that basically tells a public official to do their job, right?
Yes, exactly. If a government officer is refusing to issue your passport without a valid reason, you can get a mandamus from the court to force him to do it. But you cannot get a mandamus against your neighbor because he refuses to cherish noble ideals. The courts just won't entertain it.
So there is no direct legal sanction or punishment for violating a duty in the Constitution itself.
Correct. So, on the face of it, they appear to be toothless.
On the face of it. But, and this is the but that defines so much of Indian law, that doesn't mean they have no effect. The Constitution says that Parliament is free to pass other laws to enforce them.
And this is the transition to the teeth. Because while the Constitution itself won't have you arrested, the police, acting under a different law, certainly might.
Exactly. The Constitution basically delegates the job of enforcement to the legislature. And this isn't just a theory. This is where things get really concrete. In 1999, the government set up the Verma Committee on Fundamental Duties of the Citizens.
Right, and their job wasn't to suggest new duties. Their job was to audit the existing legal system and identify the pre-existing legal provisions that were already implementing these duties, perhaps without even realizing it.
And what they found was surprising, wasn't it? They found that we didn't necessarily need a bunch of new laws because the statute book was already full of them.
The Verma Committee report is fascinating. It's basically a treasure map that shows you where the abstract duties in Article 51A are hiding in the concrete sections of the Indian Penal Code and other special acts.
So let's do that deep dive. Let's look at these specific acts. This is where the aspirational duty becomes a very real prison sentence. Let's start with the easy one, the flag. Duty 51AA, respect the national flag.
Okay. The Verma Committee pointed directly to the Prevention of Insults to National Honor Act, 1971. Now, this law isn't just about don't burn the flag. The act is incredibly specific about what constitutes disrespect.
How specific are we talking?
Well, for example, did you know it's a specific criminal offense to use the national flag as a drapery in any form except on state funerals,
I did not know that.
or to use it as a portion of a costume or a uniform?
Or,
And this one surprises people, to embroider it onto cushions, handkerchiefs, napkins, or any dressing material.
wait, seriously, putting the tricolor on a cushion is a crime.
Under Section 2 of the Act, yes, it can be. It's considered disrespect to the flag's dignity. And if you are convicted under this act, you can be punished with imprisonment for a term which may extend to 3 years, or with a fine, or with both.
Wow.
So while the duty in 51A just says respect the flag, this act gives you a very, very strict set of physical protocols for what respect means. You violate the protocol, you go to jail. The duty is the principle, the act is the punishment.
That is a very sharp set of teeth. Okay, what about the duty to promote harmony and brotherhood? That's 51AE. That one sounds much harder to enforce.
You'd think so, but this is where we get into some of the heaviest criminal law on the books. The Verma Committee highlighted several laws here. First, the Protection of Civil Rights Act, 1955. This was originally the Untouchability Offenses Act.
So this is primarily about caste-based discrimination.
Yes. If you prevent someone from entering a shop or a temple or using a public well because of their caste, you are directly violating the duty of common brotherhood. And under this act, that is a serious, often non-bailable offense.
And it also brings in the Indian Penal Code, IPC, right? I'm thinking specifically of hate speech laws.
Section 153A of the IPC, this is the big one. It criminalizes promoting enmity between different groups on grounds of religion, race, place of birth, residence, language, etc., and doing acts prejudicial to maintenance of harmony.
We see this section being used in the news all the time against politicians or activists.
Constantly. If you give a speech that pits Hindus against Muslims, or North Indians against South Indians, or one caste against another, you are violating your fundamental duty under 51AE. But the police don't arrest you for violating the Constitution. They arrest you under Section 153A of the IPC.
So again, the duty provides the moral justification, but the IPC provides the handcuffs.
Perfect way to put it. And the Verma Committee also mentioned the Representation of People Act, 1951. This one is aimed squarely at politicians.
And it hits them where it hurts, their ability to contest elections.
Exactly. Section 123 of that act defines a list of corrupt practices during an election campaign. One of those corrupt practices is appealing for votes on the ground of a candidate's religion, caste, community, or language, or using religious symbols.
And what's the consequence if a politician is found guilty of that?
Their election can be declared void by the High Court, they lose their seat, and they can be disqualified from contesting any election for up to 6 years. So for a politician, the duty of harmony isn't just a nice idea. It's an existential requirement for their entire career.
Okay, let's talk about the big one. The duty to protect the sovereignty and integrity of India. That's 51AC. Where do we find the teeth for that?
This leads us to arguably the most draconian and controversial law in the Indian legal arsenal. The Unlawful Activities Prevention Act of 1967, better known as UAPA.
UAPA, the anti-terror law.
It is now primarily used as an anti-terror law, yes.
Okay.
The UAPA gives the central government the power to declare an association unlawful. And the definition of an unlawful activity in the act is any action which, and I'm paraphrasing here, questions, disrupts, or is intended to disrupt the sovereignty and territorial integrity of India.
It matches the duty in the Constitution almost word for word.
It's a direct reflection. So if you form a group that advocates for secession, for example, saying we believe state acts should break away from India, you are violating your fundamental duty under 51AC. The UAPA then steps in, the government can ban your group, and its members can be arrested and detained, often with very stringent bail conditions, for months or even years.
That is sobering. It really shows that these duties aren't just for school children reciting the morning pledge. They form the constitutional bedrock for our most serious national security laws.
Absolutely. And one more. Let's look at the environment. Duty 51AG.
The duty to protect the environment and have compassion for living creatures.
Sounds very gentle and soft, right? Compassion. But then look at the laws. The Wildlife Protection Act of 1972. This act creates a schedule of endangered species and completely prohibits trade in them. It makes poaching a very serious crime.
So if you kill a black buck or a tiger,
You aren't just lacking compassion in the abstract. You are facing mandatory, rigorous imprisonment under a very strict law.
and what about the Forest Conservation Act of 1980?
That act severely restricts the dereservation of forests or the use of forest land for non-forest purposes. You can't just get a contract and bulldoze a protected forest to build a resort. The act, enforced by the central government, stops you. It is the legal tool that enforces the citizen's duty to protect forests.
So the big takeaway here is that the teeth absolutely exist, but they're almost like dentures. They are removable. They are located in these separate acts, not in the Constitution itself.
That's a brilliant analogy. The Constitution is the gum, the acts are the dentures. But the crucial point the Verma Committee made was, the dentures are already in your mouth. Don't pretend you can't bite.
I love that. Okay, so that's Parliament's role. They make the laws that enforce the duties. Now, let's move on to the role of the courts. We know Parliament uses these duties to make laws, but how do the judges use them when they're deciding cases?
This is where the power of duties becomes more subtle, but perhaps even more profound. They act as an interpretative tool for the judiciary.
What does that mean in plain English?
It means that when a judge is trying to decide if a law is constitutional or not, they look to the list of duties for guidance. There was a landmark Supreme Court ruling in 1992 that really solidified this principle.
And what did that ruling say?
The court said, essentially, that if a law is passed that seeks to give effect to a fundamental duty, then that law may be considered a reasonable restriction on a fundamental right.
Okay, can you give me a hypothetical? I want to see how this plays out in a real-world scenario.
Sure. Let's imagine the government passes a law completely banning the use of loud, blaring horns in residential areas after 10 p.m.
Okay, a noise pollution law.
Right. Now, a truck drivers association challenges this law. They go to court and say, hey, Article 19(1) gives me the fundamental right to practice my profession. Honking is part of my profession. This law is an unreasonable restriction on my right to work.
It's a plausible argument. A right is a right.
It is. But then the government's lawyer stands up and says, Your Honor, please look at Article 51AG of the Constitution. Every citizen has a fundamental duty to protect and improve the natural environment. And the Supreme Court has ruled many times that environment includes protection from noise pollution.
So the duty acts as a direct counterweight to the right.
Exactly. The court will look at both and say, your right to practice your profession clashes with the collective duty to protect the environment. Since this law is enforcing a fundamental duty, we find it to be a reasonable restriction on your right. The duty saves the law from being struck down as unconstitutional.
So, in a way, the duties help the state justify restrictions on our rights.
In many cases, yes.
Yeah.
They provide the constitutional logic for limiting absolute freedom. This is what creates that democratic balance that Indira Gandhi spoke about when these were introduced. It's the Constitution telling the citizen your rights are not absolute. They stop where your duties to the community begin.
That's a very powerful tool for the judiciary. It allows them to read the Constitution as a complete holistic document, rather than just looking at the chapter on rights in total isolation.
It also allows courts to be proactive and issue directions. Think about all the famous public interest litigation cases, the MC Mehta cases regarding pollution in the Taj Mahal trapezium or the cleaning of the Ganges. In those cases, the Supreme Court often cites Article 51AG, the environmental duty, to issue sweeping orders to close polluting factories or to mandate the installation of effluent treatment plants. They say, the factory owner has a fundamental duty to protect the environment. He is failing in that duty, which is harming the public's right to life. Therefore, we order the factory to be closed.
So even though the duty is technically non-justiciable against a private citizen, the Supreme Court creates a clever workaround through a PAL.
Precisely. They enforce the duty by linking its violation to the violation of someone else's fundamental right, like the right to a clean environment under Article 21. It's a form of legal jujitsu.
Legal jujitsu. I like that. But not everyone is a fan of this jujitsu or of the duties in general. Let's talk about the critics, because in 1976, and even today, there is a lot of deep skepticism about Part IVO.
Oh, the criticism at the time was scathing, and it came from some of the most respected legal minds in the country.
One of the main lines of attack was the superfluous argument, that these are all just obvious.
Right. The argument that you don't need to tell good people to be good. C.K. Daftry, who was a former Attorney General of India, famously argued that telling Indians they have a duty not to destroy their own country implies that you think they are criminals in waiting. His quote was, "To tell them what their duties are implies that they are not content."
It's that harsh schoolmaster vibe again. Another prominent lawyer, A.K. Sen, made that exact point, saying it reduces the state to a scolding teacher.
It can feel infantilizing. It assumes the citizen doesn't know how to behave properly unless it's written down in the highest law of the land.
And then there's the vagueness argument. We touched on this with noble ideals. But the legal scholar D.D. Chawla went further. He said these values are beyond the ken of the general run of the people.
It's a bit of elitist critique, but he has a point. Concepts like scientific temper, composite culture, humanism, these are complex academic ideas. How is a daily wage laborer in a village supposed to interpret composite culture in a legally meaningful way?
And if the law is vague, it can be misused, can't it? Who gets to define what composite culture actually is? Does the ruling party of the day get to decide?
That is the great danger. If the definition of noble ideals or culture changes with every election, then the duty stops being a unifying principle and becomes a political weapon to harass opponents.
There's also the criticism that the list is not exhaustive. It leaves out some pretty important duties.
Yes, the critics asked, why is there no duty to vote? Or to pay taxes, which we already discussed? Or a duty towards family planning, which was a major government policy at the time? The list feels a bit arbitrary.
And finally, there's the placement argument. Critics pointed out that they tacked it on to the end of Part 4 after the directive principles.
They made it an appendage. The argument was, if they really believed duties were on par with rights, they should have placed them immediately after Part 3, in a new Part 3. By putting them after the directive principles, they were implicitly signaling that, just like the principles, these duties were also non-justiciable and aspirational.
So there was a lot of pushback. But here's the most fascinating part of the story for me. Despite all this criticism, despite the taint of the emergency, despite the vagueness, despite everything, the duties survived.
This is their ultimate political validation. In 1977, the emergency ends, the Congress Party is voted out, and the Janata Party comes to power. They hated the emergency. They hated the 42nd Amendment. They immediately set about undoing the damage.
Through the 43rd and 44th Amendment.
Right. They restored the powers of the judiciary. They strengthened fundamental rights. They repealed many of the authoritarian clauses of the 42nd Amendment. They undid almost everything.
But they did not touch Article 51A.
They left the fundamental duties completely untouched.
Which implies an eventual political consensus, doesn't it?
It does. It implies that even the opposition, once they were in power, looked at the list and thought, you know what, in principle, having a list of duties isn't actually a bad idea. It may have been born in the sin of the emergency, but its purpose could be seen as virtuous.
It's like they managed to separate the message from the messenger. The messenger was authoritarian, but the message that citizens should be responsible and contribute to the nation was something that everyone could eventually agree on.
And that consensus holds to this day. You don't hear any major political party advocating for the removal of fundamental duties. In fact, the only change has been to add to them, as we did in 2002, with the education duty.
So let's try and wrap this all up. We've gone on quite a journey, from the silence of the 1950 Constitution to the socialist experiment of 1976, through the legal teeth of the UAPA and the Flag Code, and into the judicial jujitsu of the 1990s. What is the big picture here?
I think the big picture is that the Indian Constitution is not a static contract. It's a living document that reflects the maturing of the nation. It started as a charter, primarily of rights, of what the citizen could demand from the state.
And it evolved into a charter of rights and responsibilities.
Exactly. It's like a maturing relationship. Maybe at the very beginning, it's all about what I get from the relationship. But eventually, for it to be successful, it has to become about what we build together. The duties remind us that the state isn't just a service provider. It's a collective project we are all a part of.
And that brings me to my final thought. I want to leave you, our listener, with something to chew on from all this. We talked a lot today about Article 51A, the duty to develop the scientific temper.
The duty to inquire and to reform.
Right. Now think about the world we live in right now. It's an age of information overload, of AI, deep fakes, of social media algorithms designed to polarize us. Finding the objective truth is harder than it has ever been in human history.
We are drowning in information, but starving for wisdom, as the saying goes.
Exactly. So here is the provocative question I want to leave you with. Is Article 51A actually the most important fundamental duty we have right now? In this chaotic modern world, is the duty to be skeptical, to demand evidence, to maintain a spirit of inquiry? Is that the only thing standing between a functioning democracy and total chaos?
You know, it's an incredible thought. The framers in 1976 might have been thinking about superstition and religious dogma, but they accidentally wrote the most important rule for surviving the 21st century.
Scientific temper isn't just a civic duty anymore.
It's a survival skill, a basic requirement for modern citizenship.
A survival skill enshrined in our Constitution? I love that.
And it puts the burden back on us, doesn't it? We can't just blame the algorithm or fake news. We have a constitutional duty to be smarter than the algorithm.
Well, if that doesn't make you want to go out and fact-check something, I don't know what will.
Indeed.
Thank you so much for going on this deep dive with us. We really got into the weeds of the acts, the articles, and the history. If you enjoyed this masterclass into the legal framework of our duties, and if you want to support a channel that values the spirit of inquiry, please make sure to like and subscribe to the channel Deep Dive Daily.
It really does help us keep these conversations going.
Until next time, remember, you have rights, but you also have, well, duties with some very real teeth.
Keep striving for excellence. Goodbye, everyone.
See?